You're watching the Explosive Exclusive with me, Rahul Shivshankar, and a big historic intervention by the Prime Minister Narendra Modi. The Prime Minister has called upon the Ministry of Home Affairs to submit an affidavit in the Supreme Court, calling upon his own government to go in for a revision of the very controversial sedition law, which is, of course, viewers, a colonial legacy and is applied indiscriminately by various governments to crack down on what they claim are attacks against the Indian state, but in the end, on closer analysis, result in only about 3% of convictions and seem to be applied against those that are dissenting, i.e. those that are critical of the government's working. And therefore, because of this loosely worded law, the impression is that a large number of those speaking out against the government seem to be obviously and very clearly, blatantly intimidated. Now the Prime Minister says that enough is enough, and that in this period of time where India is celebrating, very importantly, the Azadi Ka Maha Utsav, which is 75 years of India's independence, his government has been renewing and reviewing laws that are now past their sell-by date and reviewing those that have been misused by the colonial state, by the British, when they were here to suppress free speech, dissent, and of course liberalism in this country, and those that have been inherited as a result and misapplied by various state governments and politicians. Now, the whole inside story, viewers, I'm going to present before you what has led to this. Remember, the BJP has been a great spokesperson of free speech in the past. Remember, viewers, the top leadership of the Bharatiya Janata Party was jailed during the emergency, and that scarred a large number of BJP leaders. In fact, 2 generations, it can be safely said, were scalded really by the imposition of the emergency, which is, of course, a review of the sedition. That mindset will also be reviewed if sedition is watered down on the books. Now, if you remember, viewers, under the British Raj and then under the Congress Raj, a large number of those that belong to the BJP fold. Veer Savarkar was once, of course, a prime example. He, of course, is one of the primogenators of the thought process of the BJP. At that time, of course, the BJP didn't exist. It only came into existence in 1980, but its previous avatar was greatly influenced by the thinking of Veer Savarkar, and he himself was booked under sedition and suffered a great deal. Under the emergency, a large number of BJP's leaders like Lal Krishna Advani, Atal Bihari Vajpayee, several others, including the Prime Minister himself, was jailed or held or sanctioned under sedition laws, under other draconian colonial laws, including, of course, by Prime Minister Indira Gandhi herself, because she suspended the constitution. Now, I want to open this up and go straight across to Harish to get an idea. Harish, now this has been constantly debated, talked about, and it comes also at a time when the Modi government is under relentless attack by a lobby, let's put it like that, ecosystem, the opposition, call it what you want to, both internationally and domestically, for turning increasingly intolerant and fascist. So what has prompted this sudden review? Remember, the first affidavit seemed to rule out any decision to water down this particular colonial hangover. But now, with the Prime Minister stepping in, what made him so fundamentally change the government's position?
Yes, Rahul, a great change of stand by the government, and what is to be remembered is that even in this affidavit, it goes on to it has taken into taken into view the views of the civil rights activists and also human rights activists. The para 6 of the affidavit goes on to say that we are balancing the demands from the civil rights activists and also the human rights activists, but at the same time there will be no compromise on the security and sovereignty of the country. So all these will be kept in mind. But it doesn't mean that it doesn't give an indication that the government is going to revoke or repeal the section 124A. What it means is that it will re-examine and review and reassess the 124A, and the affidavit is unequivocal that abuse has to end, and these are the very same line which the government took in the last date of hearing and also in the last affidavit. In fact, the second affidavit is in line with the first affidavit, because the first affidavit was filed again while the government had opposed referring the 1962 Kedarnath judgment to a larger bench, and because the centre said that it backed sedition law, even the 5-judge bench had upheld the sedition law, and so the government is of the view that the sedition law should be in the statute book.
Harish, the timing will be noted. The timing will be noted. The timing comes when the government has been under intense attack, viewers, as I just began by telling you. And of course, Pranesh is there with us to read out the exact affidavit. Story broken by Harish, viewers, a short while back. He got this affidavit exclusively, broke it first here on Times Now. Pranesh, the affidavit makes some very important comments, especially 4, 5, 6 and 7 paragraphs. Could you take us through these?
Absolutely, not just the timing. The affidavit talks about the intent, Rahul. Let's begin by para 2. I state and submit that I have examined the subject matter of the present group of petitions concerning various aspects of the offence of sedition defined under section 124A of the Indian Penal Code, which is in existence since the pre-independence era, as well as post-independent India till date, and which has been analysed by the Honourable Court. This is the judgment that the centre had cited in affidavit number 1. This is the Kedarnath Singh versus State of Bihar. Our 5-judge bench had ruled in it. Point number 3, Rahul. I state and submit that so far as section 124A is concerned, there are divergence of views expressed in public domain by various jurists, academicians, intellectuals and citizens in general. While they agree about the need for statutory provisions to deal with serious offences of divisive nature affecting the very sovereignty and integrity of the country, acts leading to destabilizing the government established by law by means not authorized by law or prohibited by law, requiring a penal provision for such purpose is generally accepted by everyone in legitimate state interest. However, and it gets interesting here, however, concerns are raised about its application and abuse for the purposes not intended by law, which is why the Prime Minister intervened, and this affidavit says the Honourable Prime Minister of India has been cognizant of various views expressed on the subject and has also periodically in various fora expressed his clear, unequivocal views in favor of protection of civil liberties. Rahul, I underline civil liberties, respect for human rights and giving meaning to the constitutionally cherished freedoms by the people of the country. The PM has repeatedly said that one of India's strengths is the diverse thought streams that beautifully flourish in our country. The Honourable PM believes that at a time when our nation is marking Azadi Ka Amrut Mahotsav, we need to as a nation work even harder to shed colonial baggage that has passed its utility, which includes outdated colonial laws and practices.
There you have it. You see, that's why I said let's go from paragraph 4. The basic idea here, viewers, is to open the space for democratic exchange. Nikunj, this government under a lot of pressure internationally, nationally, from civil liberties groups, rights activists saying that they had undertaken a complete attack really on civil liberties in this country, that India was taking a fascist turn. You know the criticism, and now the Prime Minister sort of comes out and goes out there and orders the Home Ministry to file an affidavit saying that there should be some sort of a review of sedition law. This also changes the government's own very hardbound position. Where's this coming from, Nikunj?
Well, Rahul, let me now debunk a few notions here. And those are wrongly held notions, and therefore they should be put in proper perspective. Mr. Modi's government actually never stopped the ongoing review of the sedition law. So this review is not new. Previous governments have attempted it. Mr. Modi or his Home Ministry never stopped that review. On multiple occasions, I am personally privy to that the Home Minister himself has instructed Delhi police. There was one instance I can tell you right now, quote straight out of the episode, Disha Ravi's arrest from Bangalore, when he was particularly angry and upset about the fact in which the special cell of Delhi police arrested that young lady and slapped charges of UAPA and associate sections on her. So it is not as if that consternation has not existed in the government and that government was required to be woken up by its vocal critics or national or international, as you put them. If the government was completely disinterested in the review, or government would have taken a completely hardline position, completely illiberal position on this particular law or any other law for that matter, dealing with UAPA, etc., the Ministry of Home Affairs would have stopped the ongoing reviews in such cases. They haven't done so. And quite clearly, today they have taken a position, put it out on affidavit, that it is under our scanner too. People outside do not have to have much consternation about it. The government itself is quite alive and quite alive to the situation and quite alive of the fact that the law enforcement agencies have at some points in time, according to the courts of law, who have criticized them. I do not wish to take a position on that, but appellate courts like High Courts and Supreme Court have number of times across the state jurisdictions criticized the law enforcement for exceeding their brief. So that consternation in the government was always there. The review was ongoing, and today they have taken a sworn position in front of a court, in front of the top court of the country. So my sense is, Rahul, these are contentious issues. India as a country has a lot of precipitative tendencies. Many neutral observers have always believed that there needs to be strong anti-India laws on the statute books, and that number is not insignificant. So for any government, even during the UPA 2 when this review was on, for any government to take an absolute position is not an easy job. But quite clearly, top offices have now intervened. I have told you about the consternation of the Home Minister.
Yes.
Prime Minister's office has itself put out its position on the law. So once the top political offices of a country put their weight behind any particular situation which is giving consternation to citizens or causing some undue harm to the liberties of the people, I'm quite sure that situation gets into the domain of being resolved. One should look at it positively.
Well, Nikunj, yes, absolutely. And I want to pick up that thought where you said this was an ongoing process. In fact, the affidavit points to that. It says, and please bear with me, it says that the Honorable Prime Minister believes that at a time when our nation is marking the Azadi Ka Mahotsav, we need to, as a nation, work even harder to shed colonial baggage that has passed its utility, which includes outdated colonial laws and practices. In that spirit, the Government of India has scrapped over 1,500 outdated laws since 2014-2015. It has ended over 25,000 compliance burdens, which causes unnecessary hurdles and hindrances to people. And these have been decriminalized. Now, I wanted to ask you, because there is a very obvious need to prevent vociferous tendencies in different parts of the country from sort of escalating out of control. And I want to bring in Aryama Sundaram right after you, Nikunj. But the government has, I would say, a tightrope walk ahead of it, because while it may not scrap it, the sedition law, it also has to balance the needs of national security, doesn't it?
Absolutely, absolutely, Rahul. There is no doubt about it. As I said, that there is a very significant majority of
legal experts and neutral observers who have continued to maintain that India as a country needs strong pro-union laws or anti-India law. Anti-India tendencies need to be discouraged through the statute books. Now, governments never, on such issues, governments never have an easy proposition on their hands. So you wish to make it more in sync with the times, make it more humane. You want that the transgressions of the law by the law enforcement agencies, remember, each transgression of the law, howsoever much we may want to portray them, or opposition may be quick to criticize the government, each transgression of the law is not sanctioned or is not promoted by the government of the day. Law enforcement agencies, sometimes over-enthusiastic themselves, go ahead and probably cause that transgression, which is then criticized by the courts.
Okay.
As I gave you the example of Disha Ravi, in which case Home Minister himself was personally not approving of that action of Delhi police, which is his direct charge. So I would say that to evolve a position from here is a welcome sign. Government has moved in the right direction. Past governments have also tried, but now that the top political officers are willing to expend their political heft with this position, my sense is that this is moving towards a resolution.
Moving towards a resolution, hopefully this would, one hopes, of course, will open the doors for greater tolerance in free speech, especially of free speech. Thanks, Nikunj, our executive editor there, giving us this insight. Pranesh there, thank you. And Harish, of course, who broke this story. Congratulations to you. Big scoop. Let me open this up further. Let me go across to Ujjwal Nikam. Needs no introduction. Mr. Nikam, this is a very important development in the larger context of the debate on free speech. Mr. Nikam.
Yes, indeed, I do agree. And the loud message given by the government, central government, that they are going to revisit the law on sedition, it clearly means they would like to consider the main grievance that has been made against the law of sedition, that it has been misused by the government. Now, you see, no doubt we have to admit that state governments and at sometimes central government has invoked the provision of law of sedition, which is, according to me, at sometimes it is against the principle of the fundamental right.
Yes.
Because every Indian citizen has given a right, and clearly this law on sedition violates the fundamental right. But quite apart, the central government has made it very clear that they would like to reconsider and reassess the law. It clearly means that they would like to put such checks and counter checks also in the said law, because the main grievance is that it is misused by certain government.
That's true.
Now, you see, we know that every kitchen has a cockroaches. But you see, if we would like to have a good food, then definitely we'd like to have the kitchen in spite of the cockroaches. So what we do use the strong insecticide so that there should not be cockroaches in the kitchen. So similarly also, if a government would like to think over that, yes, that it has been misused, the government can put certain checks and counter checks in the state law. But at this stage, I would say that this step taken by the central government is a very positive step, and it's welcome.
Thank you, Mr. Ujjwal Nikam. Let me bring in Aryama Sundaram, senior lawyer. Mr. Sundaram, straight question to you. This rethink, reevaluation, call it what you want to, how far do you think the government will go? I'll just read out the exact quote for you to then assess the intent here. It says, the government of India being fully cognizant of various views being expressed on the subject of sedition and also having considered the concerns of civil liberties and human rights, while committed to maintain and protect the sovereignty and integrity of this great nation, has decided to re-examine and reconsider the provisions of Section 124A of the IPC, which can only be done before the competent forum. So, two things. What is the competent forum here? And of course, when they say, while committed to maintaining and protecting the sovereignty, integrity of this great nation, has decided to re-examine and reconsider sedition law. What does the government say here? What do you think it is saying?
I think it's fairly clear what the government is saying. We've had several discussions on this in the past also. And like I said earlier, we can't throw the baby out with the bathwater. I, for one, believe that there ought to be a law regarding sedition. But at the same time, I say that law must be in a straitjacket. It must be very clearly defined and very clear as to what would amount to sedition, which can only be if India's sovereignty, not the government of the day, but India's sovereignty is attacked, if its integrity is attacked, if its security is attacked, that is India, not the government of the day. So I've always maintained this is what was originally the intention, I'm sure, of sedition when it was first thought of, treason as it used to be called in the old days. But over a period of time, it's been misinterpreted in many ways. And that is why you have different governments of different states, irrespective of which political view they're of, misusing this provision. I think, therefore, what the government is today saying is a very positive step. And to answer your question directly, I think the government has said three very clear things in this. Number one, the law of sedition is necessary. So far as sovereignty, integrity, security of the country is concerned, it is necessary. Number two, while it is necessary, one should also keep in mind the views of various civil liberty groups, other groups, which in other words means one should also keep in mind the civil liberties assured, the fundamental rights assured, and see how that is done. And to that extent, it is a very delicate balancing act. And it is really a balancing act to ensure that without impinging on fundamental rights and legal exercise, constitutional exercise of such fundamental rights, at the same time, the security, integrity, and sovereignty of the country can be maintained. And this seems to be the attitude of the government, not that they're going to scrap the law, but they're going to tinker with it, temper it, to see that it comes in line with upholding the constitutional principles found in the fundamental rights. And thirdly, the government has also made it clear that this is a matter for Parliament to decide, in that the forum which will decide it will be Parliament. And it is being reviewed and therefore has asked the court, has requested the court as to whether the court could allow such a review to take place, give the government a chance to rethink as to how this can be tempered, how this balancing act can be arrived at, and how a fair sedition law can be brought in, a sedition law which really addresses the problem and doesn't become a tool of misuse, and on that basis is asking the court to defer. That is the way I read the government affidavit.
Well, that's very important. The right forum being Parliament, primacy of Parliament. Parliament can, of course, undertake this exercise. Kapil Madan, let me bring you in. Now, this is interesting because optically, this is a masterstroke also. You have been criticizing the Modi government for being, having a tinge of fascism in its outlook, that it is extremely intolerant, etc. You promised in 2019, the Congress that is, to come out and if it was elected to power, scrap sedition. But here the government is going to, if not scrap it, but temper it to a point where it cannot be misused. So that really takes away from your entire attack on Modi himself, that he is some sort of a fascist, Hitlerian kind of character, Stalinistic character. Now that's completely gone, because this is as far as you can get from the emergency mindset that we saw clearly in 1975.
So Rahulji, let me begin that by unequivocally stating that it is a step in the right direction, because there is never a wrong time to do a right thing. It is a right thing. And having said that, I would also like to tell your viewers that if you see the data clearly shows that since 2014 there has been a substantial increase in the number of the cases that have been filed under this particular section, that is 124A, and out of 10,000 cases that have been filed, about 65% of the cases are, political in nature. And if you really see and do a research, you would find hardly any, convictions on insofar as sedition is concerned. So my view here would be it is a step in the right direction. It would, we earlier had a case where in Shreya Singh's case, the Honorable Supreme Court intervened and interpreted the law to say that there are no checks and balances, and therefore it struck down 66A. To me, it sounds a little paramateria to what was happened in Shreya Singh's case, and I would conclude by saying it's a step in the right direction.
Well, you didn't answer my question, which was more of a political question to you, Mr. Madan, that while you have been attacking the Modi government for being absolutely intolerant, it has come up with a answer, very robust answer in wanting to water down this particular provision. It had also brought in a very humanitarian law like the CAA, which you opposed. It struck down Article 370 and its attendant and accompanying 35A, which was extremely discriminatory. Again, to widen. So you didn't answer that. It seems that the government is going to snatch that one particular, how should I put it, plank that you have used against the government, which is that the Congress and its ecosystem is the more liberal one, not the BJP and its ecosystem. Nonetheless, I presume that you will now concede that that particular...
No, I will respond to that. I will respond to that, and I will now give you a political answer, Rahul. Now, we've seen an indiscriminate use of sedition law for the past 8 years, and it is because of what has happened, the way their illegalities and the way...
No, but there have been also transgressions and overreach in opposition rule states. Now, don't play this selectively. All I'm saying is,
now let me
when was the last time sedition was applied? In Maharashtra.
And I'm giving you a political answer now. If you see the data, there has been a substantial increase in the sedition offences.
Sure. But it has happened across the board. Opposition rule states have not been far behind.
Now, Rahulji, your argument is little self-destructing, because now you are also admitting that the sedition law was used in a way to strike a political vendetta.
Of course.
By BJP.
Of course. What makes you think it wasn't? Let me take you back. No, 1 minute. Let me take you back to an article I had written in the Times of India. I said opposing sedition law is good optics and politics. With Section 66A and Article 35A ended, NDA government should do the same for Section 124A. I've been a champion of getting rid of this sedition law. It is long. No, hang on. So you're preaching to the converted. All I'm saying is, in a political viewers, in a very political narrow spectrum, the opposition is fast losing an important tool with which it used to target the government and call it intolerant and fascist. Shazia Ilmi, are you going to go the whole hog? Do you even need to go the whole hog? Is it being done under pressure? We know that India's democratic slide is being captured in various international indexes. Is this a reaction to that?
No, by that logic, we should be scrapping it. So, and one need not be an absolutist on any issue whatsoever, and one would not be so puerile as to confuse the any kind of dissent or opinion, negative or adverse, against the Indian government with India whatsoever also. But the fact of the matter is that I will not even go as far as 1962 and look at the Kedarnath Singh case. My own father, when he was a young man, 1957, Muhammad Isaac Ilmi versus State. It was the first sedition case, actually, which was slapped on him. So I know a little something about it. But let's not even go there. So it's very easy, and I can give you a political answer too.
No, give me a political answer. I don't want the legal answer. I'm only asking you, under pressure, is this being done under pressure?
The political...
No.
Yeah,
yes.
So... No, under pressure there would not be. Okay. So under pressure it would be the other way around, is what I'm saying.
Okay.
Under pressure it would be to give that, oh my God, we should... So no. Let me come... There are more facts than that. So if you look at whether it's Umar Khalid or Kanhaiya Kumar, or look at Sharjil Imam, and the latest time when this was even imposed is against the Ranas by the Maharashtra Ghadi government, which has nothing to do with the BJP whatsoever. So now Kapil Sibal has been, from the Congress, has been talking about scrapping it. But the fact of the matter is, whether it is Asim Trivedi on the making of the cartoon, or Anna Hazare movement, or throwing of Anna Hazare in the jail, or getting all of us beaten up during the Nirbhaya Andolan, or Anna Hazare, or throwing an octogenarian like Anna Hazare in the jail, or 7,000 villagers of
What's the point?
Kudalam, I can never pronounce it, sorry about that, in the jail. The point is that there have been, so BJP keeps getting accused of the same, but the fact is when people say something like Afzal hum sharminda hain, tere qatil zinda hain, let's not mistake freedom of speech with sedition. When people are planning and plotting, cutting off and talking about chicken's neck and actually making plans on those lines, we have to be serious because this affects India's sovereignty.
Fair enough, I've understood.
So I'm saying,
I just want to bring in Deshratan Nigam. Deshratan Nigam, 30 seconds, sir. Should we go the whole hog, scrap it completely, or should we go halfway and set guidelines like Aryama Sundaram is saying so that its misuse is tempered?
One thing is very clear, that the wording of the law as of now is of the British era. However, its scope has been narrowed down by 1962 judgment, where it brings in the concept of a violence against a state or inciting violence or a possibility of violence due to written or oral words. So its scope has been quite narrowed down. It has been made suitable for India, not under British, but an independent India. Now, the fact remains, since any law in India has been misused, not only this law, but most of the laws have been misused. What can be done at best is through a process of parliament, as Aryaman Sundaram said so, that the parliament is the right forum to bring in amendments or any proviso to these laws. To the best of my knowledge and ability, I think the violence aspect can be brought in this law. And because of, the various issues that we have, insurgency, certain part of the country, and terrorism also, and Maoism, Naxalism, urban Naxalism also. So all those aspects need to be taken care of. It cannot be scrapped, let me tell you.
Okay, it cannot be scrapped. So in a review, temper it, put codified guidelines, don't get rid of it. Fair enough. I think that's, I think both are legal experts coming with that point of view. Well, I suppose this matter will come up now sooner than later in Indian Parliament, perhaps in the upcoming monsoon session, where there might be actually amendments brought to this particular section 124A of the IPC. Viewers,